Hello, everyone. Lyric Armstrong, a real estate agent and advocate. Today, we're going to talk about um, some very important aspects of real estate that a lot of people don't think about because a lot of people are only focused on acquiring their real estate and maintaining it through the time that they're living in it. But there is an important understanding that all assets, including your real estate, how it is inherited, if you will, or disposed of upon your death. So a lot of people feel, I have a will, I'm good, I wrote it up, it's in my handwriting, I've attested to it, I've got it notarized, whatever the factor, and they save it and put it in a lockbox, and they believe that to be sufficient. Realities have hit for some to understand that not quite. So let's take a look at Aretha Franklin, because a lot of times we don't know or don't want to learn unless it's like learning from someone's wrong, whether it's your own wrong or someone else's wrong. It's the only way some people want to learn. Some people are just hard-headed that way, to be kind of frank about it. But we can learn. Let's learn. It's a good time to learn. So taking a look at MSNBC, an Insider Edition video. Let's just have a few minutes, very quick. All right, let me make sure you can hear this.
Written note by Aretha Franklin found stuffed in a couch can serve as a will, according to a Michigan jury. It's quite a plot twist in a long-standing dispute over her estate between her two sons, Kelf and Edward Franklin, whose lawyers argued that papers dated 2014 should override a 2010 will that was found around the same time in a locked cabinet at their mom's home in suburban Detroit.
I think that she would be very happy and she's proud right now that her wishes have been agreed to.
Aretha Franklin did not leave behind a formal typewritten will when she died in 2018 at age 76. Both documents were scribbled and hard to make out, and suddenly emerged in 2019 when a niece scoured the home for records. In closing arguments, lawyers for two of Franklin's sons said there's nothing legally significant about finding the handwritten papers in a notebook in her couch. Kelf and Edward have teamed up against brother Ted White II, who favored the 2010 will. White's attorney noted the 2010 will was under lock and key. He said it's much more significant than papers found in a couch. Franklin's estate managers have been paying bills, settling millions in tax debts, and generating income through music royalties and other intellectual property. The will dispute, however, has been unfinished business. There are differences between the 2010 and 2014 versions, though they both appear to indicate Franklin's four sons would share income from music and copyrights. Under the 2014 will, Kelf Franklin and grandchildren would get his mother's main home in Bloomfield Hills, which was valued at $1.1 million when she died, but is worth much more today.
We just want to exhale right now. It's been a long 5 years for my family, my children, and we just want to exhale, truthfully.
Okay, so that is like the major point. It ended on the major point. Realities are, your will does not have to be perfectly in perfect format. We've talked about this before. Contracts that are written, one-pagers, as long as there's the elements of a contract are suffice, then the whole thing suffices. It doesn't have to be in a certain format. However, the type print would be nice so that we can read it in case we can't read your handwriting. And we want to make sure that we are adhering to all of the wishes. But if we can't read your handwriting, then maybe having it typed up is better than writing it. But nonetheless, that's not the most important part. The most important part is they were been in court for 5 years. The Queen passed away. Not the Queen, but the Queen of Soul passed away August 2018. We are now July 2023. This is basically 5 years, 4 years and 11 months. Like we are right at 5 years pretty much before there is resolution as to which document would prevail, which document would be counted as the will. And there are some indications as to how she wanted her property disposed of. I think the main house goes to one son and maybe some other property, but that's kind of neither here nor there. My point is, when you don't have a trust, when you don't have um, your will and a trust, it goes to court. And you heard them say there was a accounting or maybe a supposition, could have been, I don't know if it was an official financial accounting, but there was a thought that her asset was $80 million when they first started 5 years ago. And now they're looking at the assets being worth $6 million. Now, I'm sure they're not really accounting for the music, because the music is obviously phenomenal and should be worth more than that alone. But nonetheless, this is what they're reporting now, $6 million. So that's a grave difference. And quite honestly, that may not be the true difference, but the realities are, when you are probating or you are litigating, you're in court for 5 years, you are doing nothing but taking money from the estate. You are spending money to fight the estates. And it's a long road and it's a costly road. So there's a difference between, an average is 2 years. This took 5 years, right, to go through court just to determine what document would prevail. Now, I don't know if there's going to have to be other proceedings, but that's what they found this week. Now, the average is about 2 years to go through probate. But when you have a trust, it's like 30 to 90 days to completely disseminate all assets to where you want them to go. And they don't have to go to court and pay court fees and pay attorneys and pay filing fees and all that. So my suggestion, because I can only suggest, I cannot advise, you're not my client, but my suggestion is that you go and get a trust and have all of your assets in the trust. I don't care who you give them to. You can give them to cats, dogs, you can give it to the orphanage, you can give it to your kids. You don't have to give it to your kids. That's not my business. But I just, please, I beg you, at least have your trust in order, so that when your day does come, because we all will get there, there's no avoiding it. So, and there's no telling when that time is. So don't wait, do it now. So that when your day does come, there's no question and there's no one else profiting off of your death, basically. We don't want the government or the court to profit off of your death. We want you to have gotten your paper in line, got your trust, not just your will, but your trust in line, so that your family and your friends or your church or your whoever your beneficiaries are not waiting around or not fighting for it. 5 years is a really long time to just figure out which will we're going to talk about. Which will is it? And like they said, for 9 months, they didn't think she had a will. Then it was they found wills because they were going through the house. So, I mean, you need to, I would hope that you would have a trust and have a representative that as soon as you pass away, they can say, here is the trust, here are the documents, here's the will, here's everything that goes into the trust, and this is how all items are disseminated. Thankfully, they got some type of resolution this week. Been a long road, but for you and your learning, because you are still here on this earth, you can learn to have a trust and not just a will. All right, Lyric Armstrong, your real estate agent and advocate. Rest in peace, Aretha Franklin, Queen of Soul.